The case is Mullen v. Doe, and it was decided basically last Friday, June 25th, 2026. And it actually is two cases, okay, uh, consolidated together, which means the court said, hey, these are similar issues, so we just going to put them together. That's consolidated. And one involved Syrian TPS holders, and the other involved Haitian TPS holders. But since most of y'all don't know where Syria is on the map, I'm not going to even bother telling you about that one, but it's over there. We'll just say it's over there in Arab people land. Okay, it's over there by Israel. We don't need to talk about it. Y'all don't know. Y'all know what Haiti is. That's the place kind of by Jamaica, but not really that y'all fly over. Um, but anyway, let's get back to it. So we're not going to too much deal with the Syrians, but but the Haitians, right? The Haitian TPS holder. And the basic question was whether the federal courts could stop the government from ending temporary, in other words, stop Trump from ending temporary protected status or TPS for these Syrians and Haitians, and while the lawsuits continue. And the Supreme Court said no, no, you can't. And they ruled 6-3. There are 9 Supreme Court justices. 6 of them said no. 3 of them said yes. And then you had Justice Alito writing for the majority, in other words, the winners, and Justin Kagan writing for the dissent. And she was joined by Justice Sotomayor and Justice Ketanji Jackson. And the split was sharp, straight down ideological lines. And the majority treated this like a statutory power case. Like there was nothing emotional about it. But the dissent, okay, Ketanji, okay, and Justice Kagan and Justice Sotomayor, right? They treated it like it was a human catastrophe mixed with legal violations. And so the background is simple. Congress treated TPS in the 1990s, or created it in the 1990s under Bill Clinton. It was a humanitarian relief for people who couldn't safely return to their countries because of, extraordinary conditions like natural disasters. And Haiti received TPS in 2010. And that was after that earthquake that killed hundreds of thousands of people, hundreds of thousands, and destroyed property and made the living conditions horrible. Okay. And Syria got theirs in 2012 because there was a crazy man named Assad, and he was doing crazy things and just killing civilians. But the key phrase is the majority opinion is the temporary is this is what they said, temporary. The court stressed that TPS was created as a temporary program. And to me, they're yelling at the minority like, hey, fool, temporary means not forever. Okay. And this is lawyers talking to each other, explaining it to each other, but justice, but anyway, uh, even though in practice it often lasted for decades, it was still temporary. So Justice Alito pointed out that Haiti's TPS designation had effectively allowed Haitian TPS holders to keep that status for 16 years. And that matters because the majority's basic posture was that this program may have become long-term in real life, but Congress still wrote it as a temporary relief. In other words, hey, they've been here. I guess they thought, well, they've been here so long, we might as well give them a path to citizenship. And the majority said, no, temporary means temporary. Whether you're here for 16 months or 16 years, you gotta go, gotta go. Shout out to Atamara. Thank you so much. Now, this matters because, again, the majority posture was the program may have become long term, but it was supposed to be temporary. So, how did this case get to the Supreme Court? Well, the Department of Homeland Security, somebody type ICE in the chat room, announced that Syria's TPS was going to be terminated, and 7 Syrian nationals immediately filed suit in federal court in New York. Very friendly venue for them because very friendly, liberal type state. Then the government announced that Haiti's TPS was about to be terminated, and 5 Haitian nationals sued in the federal court in Washington, D.C., another very friendly venue. Okay, this is liberal town, right? Liberal places. And so those lower courts granted it would leave. Of course, that's what they're going to do. That's how the politics are played. Liberal judges, Republican judges, conservative are different. You kind of already know how it's going to go. The bottom line is the lower courts granted the TPS or granted the relief, meaning they stopped the terminations from taking place or taking effect, I should say. And while the litigation continues, in other words, y'all keep this going until the case is resolved. hopefully Trump won't be in office and we'll get another Democrat in there, but it didn't work like that, right? So the Second Circuit DC court refused to give the government a stay. So the government went straight to the Supreme Court and asked the court to step in before the normal appellate process finished. In other words, the government said, hey, we don't want you to honor that lower court's decision. We want you to stay that and don't make us stop. We want to go ahead and get these people out of here. We only got 4 years. So the government said, nah, the Second Circuit said, nah, we're not gonna let you do anything. And so they appealed that to the Supreme Court because they want to get these people out of here. Okay, and that's important. And this wasn't a slow, ordinary appeal after a final judgment. This was certiorari before the judgment. So we haven't even tried the case yet. We're gonna get these people out of here. Okay. And the Supreme Court jumped in early because the government said the lower courts were blocking immigration policy and interfering with the executive branch's authority. And the majority of the Supreme Court said, yeah, that's what they're doing. We see it, right? And they said TPS statute plainly prohibits the non-constitutional claims. Okay. The statute says there's no judicial review. Basically said you can't tell the president what to do. It says it right there in the statute, right? Any determination by the Secretary of Homeland Security with respect to the designation, termination, or extension of TPS for a foreign state. Now, I want y'all to understand something: executive, legislative, judicial, 3 branches of government. Not trying to give y'all a lesson, but Secretary of Homeland Security falls under the executive branch. So if you're trying to stop the president, if you're trying to stop the Secretary of Homeland Security from doing something, then you're basically trying to stop the president from doing something. So you're in violation of the separate branches of government institutions that we have set up. Now, the majority read the language broadly, not narrowly. And Justice Alito said, this is clear. You can't tell them what to do. It's plain. What's wrong with you? Why are y'all tripping? We got you. It's over. And that's the court's way of saying these lower courts, you had no business getting involved in this in the first place. Okay. Shame on you. That's basically what it says. So the majority also rejected the argument that the courts could at least review whether the secretary followed proper procedure. They said, nope, you can't touch it at all. Get on, mind your business. Okay. The majority said no. So this effectively says, you let us find out you keep fooling with this man and the CPS again. Do it again. That's basically what they said. Do it again. Okay. And so, and I'm gonna take this off the screen because I know y'all don't want to see that boring case. But so that's basically what they said. Now, Justice Alito basically said that the secretary did something that abused Congress, abuses the Congress should deal with it, not you. Okay, and that's the cold legal answer. And the court's message was not every abuse is for the court to fix. It's not our problem. Yeah, it's abusive. You sending these people back to a gang zone, there's going to be a lot of graping going on, but that ain't our problem. Talk to Congress. Okay, and then the court turned to the race claim involving Haiti, and the Haitian plaintiffs argued that the termination of Haiti's TPS was motivated by race, and the majority assumed without even deciding that stronger Arlington Heights equal protection standard applied. But even under the standard, the majority said the claim was unlikely to succeed. Why? Because Justice Alito said none of the cited statements by President Trump or Secretary Nolan was racial. That's what they said. Okay. Now let's talk about the dissent. Okay. Well, let me say this. Justice Alito also made the point that cuts directly against the Haitian plaintiffs. He said that the administration had terminated every TPS designation, not just for Haitian. And that came up for review 13 and it covered. That was East Asia, Central Asia, Middle East, Africa, Central America, South America, and the Caribbean. And the majority used that as an evidence that the policy wasn't just targeting Haitians or anti-Black. We getting all these people, all these dark brown people and Black people are getting out of here. You see what I'm saying? Now, of course, Justice, the 3 dissenting justices, Justice Kagan dissent is where the fire is. She starts by saying that for more than a decade, the government allowed Haitian and Syrian nationals to live and work in the United States because their countries were too jacked up to return. And then she says the court is now undoing that preliminary relief and forcing determinations that's going to take effect immediately. So they gone. Okay. Her one of the strongest lines she said is she says the plaintiffs are entitled to remain while the cases go forward, and she dissents from the court's decision that they should be put on the next plane. You see what I'm saying? She basically said they may be put on the next plane. That's some strong language, and that's about as close as a Supreme Court justice gets to saying this court sending people into danger. Kagan also goes directly at the majority statutory reading, and she says that the majority said the word determination includes the whole chain of events leading up to the final TPS decision. And I know this is boring, but I think it's important. Okay. Now Kagan, she said she called that reading not just broad but strange. They are shooting barbs at each other. I know y'all don't understand this, but this is tough stuff they talking at each other. Okay. She even mocked the majority's logic when one word she said, voila, right? That's the Supreme Court sarcasm. That's the justice saying the majority just magically expanded the statute to make plaintiffs lose. So she came with it. She also quoted statements about Haitians. And then when she said, y'all said there's no race involved, y'all haven't heard the president said anything racist. And she said the evidence of racial motivation was plain to see. She pointed out the majority wouldn't even repeat the statements from Trump, from President Trump when he but she did repeat it. She in this opinion, it says the Haitians are eating dogs and eating cats, probably having AIDS, HIV being Haiti is being a shithole country. Haitians are poisoning the blood of the country. And this is what she said, and they're gonna be reading this 100 years from now, right? And then she said the references to filth and disease and primitiveness were shot through with racial stereotypes and tropes. This is what she said. Y'all say ain't no racism, right? That's pretty racist to me. That's what she said. The Supreme Court justice, not me saying. I'm just reading what it said. And that's some very strong judicial language. And Kagan wasn't just disagreeing; she was accusing the majority of sanitizing the record, hiding stuff, lying. And she said judges are required to be naive. Okay, we don't have to be stupid, right? And her point was simple: Haitians are black, Norwegians and Swedes are not. So when the president contrasts Haiti with Norway and Sweden and talks about Haitians with language of filth and disease and blood and poisoning, Kagan says you don't need to pretend you can't see racial message. It's right there. Okay. So I thought that was pretty strong language. That was some pretty strong language, but that's drama. I know y'all don't get it, but it means a lot to me. That's some Supreme Court drama. Okay, the dissent spoke in the language of uprooted lives and danger, and families left behind, and race-based tent. And that's the drama of this case. The majority said Congress wrote it in the statute. This is what it says. It gives the secretary enormous power. We're good. It's none of our business. That's basically what they said. Okay, and in the meanwhile, you got the three justices on the dissent saying the secretary likely violated the statute of race and likely infected the Haitian decision. And the court is allowing hundreds of thousands of people to be thrown out the country. And that's the split. And that's why this ruling mattered before we even get to the question of why Black America is so quiet. So they going home. They about to go home. They gonna get up out of here.